The calm before the argument. There is something unsettling about how calm Luigi Mangione looks. Not because calm implies innocence, not because calm proves guilt, but because calm, in a case like this, feels deliberate. He sits at the defense table in Manhattan courtrooms as cameras click, smiling faintly, sometimes even acknowledging photographers. This is a man facing the possibility of life in prison or death, yet he doesn't look like someone bracing for impact. He looks like someone waiting for something to happen. This dissonance is where this story begins. On paper, the case against Mangione appears overwhelming. A prominent healthcare executive is murdered in broad daylight on a midtown sidewalk. The killing looks targeted, methodical, political even. Within days, investigators identify a suspect who had disappeared months earlier, left behind troubling writings, and resurfaced hundreds of miles away under circumstances so surreal they feel scripted. From the outside, it looks like the kind of case prosecutors dream of. Motive, preparation, flight, and physical evidence all pointing in the same direction. The sort of case where the verdict feels inevitable. And yet, this case is not moving toward trial the way most open and shut cases do. Instead, it has slowed, stretched, complicated itself. Pre-trial hearings that usually last hours have ballooned into weeks. Evidence that prosecutors assumed would sail through has become the subject of intense judicial scrutiny. Statements once thought usable are now gone entirely. And the defense is not acting like a team preparing for damage control. They're acting like a team preparing for war. That posture matters. Because defense attorneys don't behave this way unless they believe there's a pressure point. Something fundamental. Something structural. Something that, if removed, could collapse the entire case, or at least fracture it badly enough to introduce real doubt. This is not a story about whether Luigi Mangione is a good person. It's not about whether his ideas were justified, or whether anger toward corporate healthcare resonates with a public already primed to distrust powerful institutions. And it's certainly not about turning him into a symbol. This is about process. It's about rules that exist precisely for cases like this. High-profile, emotionally charged, politically radioactive cases where the temptation to cut corners is strongest. And it's about what happens when the defense believes those rules weren't followed. Importantly, none of this means Mangione didn't do what he's accused of doing. Based on what is publicly known, it is entirely plausible that he did. There may be evidence prosecutors haven't shown yet that seals his fate beyond any reasonable doubt. That possibility should never be dismissed. But trials are not about plausibility. They are about proof that survives scrutiny. And the defense's wager, whether it ultimately succeeds or not, is that this case rests on a fragile foundation. That key steps taken early, under pressure and uncertainty, created vulnerabilities that can't simply be patched over later with confidence or narrative momentum. What follows is not speculation for speculation's sake. It's a careful walk through how a modern defense team dismantles a case, not by shouting innocence, but by asking quieter, more dangerous questions. Were the rules followed exactly as they're supposed to be? If not, what disappears when the rules are enforced? Because sometimes the strongest defense isn't proving what didn't happen. It's proving what shouldn't have happened at all. The case rests on a single moment. Every criminal case, no matter how complex, eventually narrows to a few critical moments. Moments where decisions are made quickly. Moments where procedure either holds or bends. Moments that don't look dramatic at the time, but later determine whether a jury ever hears the most damaging evidence at all. For Luigi Mangione's defense, everything begins with one such moment. Not the shooting itself, not the manhunt, not even the arrest. The case hinges on what happened after Mangione was already in custody. Because once a suspect is secured, the rules change. Police are no longer reacting to danger, they are documenting it. The law gives officers wide latitude in chaotic situations. But that latitude narrows sharply once the threat is neutralized. What the defense is arguing, in essence, is that law enforcement crossed that line without realizing how much it mattered. And if they're right, the consequences are enormous. The physical evidence, and why everything depends on it. At the center of the prosecution's case is a single collection of items recovered at the time of Luigi Mangione's arrest. Not testimony, not ideology, not inference. Physical objects that, taken together, form the backbone of the state's narrative. According to police testimony, when Mangione was detained, officers took possession of a backpack he had with him. Inside, they found what prosecutors describe as a near-complete toolkit of flight and preparation. Most significant was a 3D printed handgun fitted with a suppressor, along with ammunition. Investigators later said ballistics testing connected that weapon to the fatal shooting of United Healthcare CEO Brian Thompson. If admitted at trial, that alone would be devastating evidence. But the bag contained far more than a firearm. Officers also recovered handwritten notebooks filled with detailed notes. Prosecutors characterized these writings as a manifesto and operational journals. The pages included travel routes through multiple Midwestern cities, reminders about altering appearance, and planning language that investigators interpret as preparation to evade law enforcement. There were references to momentum, timing, and staying ahead of federal authorities. Also inside were foreign currency, electronics, survival gear, and miscellaneous supplies, consistent, prosecutors argue, with someone preparing for extended movement without detection. In short, the backpack did not just contain evidence of a weapon. It contained a story of planning, motive, and intent. And prosecutors intend to tell that story to a jury as a seamless narrative. Assassination followed by escape. The defense's response is not to dispute that the contents look incriminating. Instead, they argue the jury should never see them. That position is rooted in timing and authority. By the moment officers opened the backpack, Mangione was already detained, seated, and under control. There was no chase underway, no immediate safety threat, and no risk that evidence could be destroyed. The defense contends that once the bag was secured, police were constitutionally required to stop and obtain a warrant before examining its contents. That argument might sound technical, but courts take it seriously. The Fourth Amendment does not prohibit searches, it regulates them. Warrantless searches are allowed only under specific conditions, and once those conditions disappear, so does the justification. The defense insists that whatever authority officers initially had ended the moment Mangione was fully restrained and separated from his belongings. This is not merely theoretical. During testimony, officers acknowledged that evidence transfers were not perfectly documented. Some bags lacked time labels. Handoffs occurred without complete notation. Individually, these are minor lapses. Collectively, the defense argues they show a process driven by assumption rather than caution. And assumption is dangerous when constitutional rights are involved. Body camera footage added another layer of complication. In recordings played during the hearing, officers themselves can be heard debating whether a warrant was necessary before examining Mangione's belongings. That uncertainty is now central to the defense's argument. If officers on the scene were unsure of their authority, the defense argues, the search itself cannot be treated as unquestionably lawful. The suppression hearing became the arena where these details mattered. Not whether the items were suspicious, but whether they were lawfully obtained. The defense cross-examined officers on sequence, procedure, and training. They highlighted hesitation, uncertainty, inconsistency. If the court agrees with the defense, the consequences are immediate. The firearm, the notebooks, and everything tied to them would be excluded. Prosecutors would be barred from showing them to a jury or even referencing their existence. That would not end the case, but it would fundamentally weaken it. Without those items, prosecutors would be left to rely on surveillance footage, travel behavior, and circumstantial evidence. A case that currently appears airtight would become far more vulnerable to doubt. Judges are cautious about taking that step, especially in a high-profile murder. Courts generally prefer to admit evidence when there is any plausible legal justification. The defense knows this, which is why they treated the suppression fight not as a formality, but as a decisive battle. Because in this case, the backpack is not just evidence. It is the case. What the jury may never hear. While the fight over physical evidence has drawn the most attention, it is not the only front where Mangione's defense has made progress. Quietly, and with far less public drama, they have already succeeded in removing something else prosecutors typically rely on heavily in cases like this: the defendant's own words. Statements are powerful. They humanize a case for jurors. They provide tone, intent, and psychology in ways physical evidence cannot, and they are often where prosecutors believe the real story lives. That is precisely why the defense moved quickly to limit what Luigi Mangione ever said after his arrest. Shortly after Mangione was taken into custody, New York investigators traveled to Pennsylvania to interview him. A recording setup was prepared in the interrogation room. What followed is now one of the clearest procedural missteps acknowledged by the prosecution. Mangione invoked his right to an attorney. At that point, questioning should have stopped. Instead, while investigators left the room, the recording equipment continued to run. Mangione was not informed that audio and video were still being captured. Pennsylvania is a two-party consent state, meaning all participants must agree to being recorded. Under oath, an NYPD lieutenant later admitted he did not know whether the recording was legal. That admission was enough. Rather than litigate the issue further, prosecutors withdrew the statements entirely. Whatever Mangione said during that recorded period, whether incriminating or not, will not be played for a jury. The judge accepted the withdrawal without dispute. This matters more than it may seem. Cases like this often hinge on subtle statements, reactions to evidence, emotional slips, ideological rants, offhand remarks that prosecutors use to build motive and mindset. Even silence, when captured improperly, can be framed as telling. All of that is now off the table. The defense didn't argue innocence here. They argued process, and they won. They are now attempting the same approach with other post-arrest statements attributed to Mangione, including remarks made to jail staff. Prosecutors characterize these as voluntary conversations. The defense argues they occurred while Mangione was under constant observation and psychological pressure, raising questions about fairness and context. Courts are often reluctant to exclude unsolicited inmate statements, so this fight is less certain. But even partial success, limiting how those statements are framed, could reduce their impact. Taken together, these exclusions matter because they force the prosecution to rely less on narrative and more on structure, less on what Mangione said, more on what can be proven cleanly, procedurally, and beyond challenge. And that brings us to credibility. Throughout pre-trial proceedings, the defense has repeatedly highlighted instances where law enforcement overstated or misrepresented facts. The most notable example involves a statement attributed to Mangione's mother early in the investigation, one suggesting she believed her son capable of committing the crime. According to the defense, that statement does not exist. They subpoenaed records. They checked reports. They found no documentation supporting the quote. Instead, they argue the mother said the opposite, that she did not believe her son posed a risk to anyone. The defense has placed this discrepancy squarely on the record. They are not arguing that it proves innocence. They are arguing that it demonstrates a pattern. Conclusions first, verification later. That pattern, if accepted by jurors, can have outsized influence. Jurors rarely believe police fabricated cases wholesale, but they are receptive to the idea that investigators can become convinced too early and interpret everything through that lens. The defense is also expected to remind jurors that prosecutors initially pursued terrorism-related charges, only to have those dismissed by the court. Again, not proof of innocence, but another example of overreach corrected by judicial review. Still, it's important to be clear-eyed about what this strategy does and does not accomplish. Even if the defense succeeds in suppressing evidence, even if statements remain excluded, even if jurors are skeptical of investigators' conduct, Luigi Mangione can still be convicted. Prosecutors may prevent additional evidence not yet fully public. Surveillance footage, travel records, digital forensics, expert testimony. Any of these could independently persuade a jury. And juries are often willing to convict even when some evidence is excluded, particularly in cases involving targeted violence. The defense's strategy does not prove Mangione didn't do it. It attempts something more modest and more realistic, to narrow the case until it becomes fragile enough that unanimity is no longer guaranteed. One juror unsure, one juror unconvinced, one juror focused more on how the evidence was obtained than what it suggests. That is how exonerations sometimes happen, not through dramatic reversals, but through attrition. Whether this strategy succeeds will depend on rulings still pending, evidence still unseen, and arguments still to be made. It is entirely possible that despite every suppression motion and procedural challenge, the remaining evidence will be enough to convict. But what is already clear is this: Mangione's defense is not preparing for mitigation. They are not positioning for mercy. They are not conceding ground. They are attempting to dismantle the case at its foundation. And in a system built on rules, sometimes the most dangerous argument is not "he didn't do it," but "you didn't prove it the right way." That question, quiet, technical, and deeply consequential, is what this trial will ultimately turn on. Do you want to bring bad things with you wherever you go? Our episodes are now available as a podcast. Look us up on your favorite podcast app and listen to the most truth-seeking true crime podcast out there.